Hi, welcome to Pro CS. Okay, how you all are doing? I'm also great. So today we see cases in Indian Contract Act, and this has been most loved, most adored act, most admired act also. And why? Because you know the reasons. You have started with this since your very inception into the CS course. So जिस दिन से आपने CS कोर्स ज्वाइन किया है उसके बाद से ये एक्ट आपके साथ जुड़ा हुआ है. So let's quickly see the past cases, क्या क्या हुए थे, कैसे हुए थे, and you know the act by heart. So let's understand क्या क्या cases हुए हैं और इसके answers हम कैसे लिख सकते थे. Okay, so that gives you an idea how you would be tackling these kind of questions, and can there be repetitions? So you will come to know. So let's see that. Ajay finds a mobile phone lying on a table in a coffee house. Fine, he finds a mobile phone. He hands over the mobile phone to Bijoy, the manager of the coffee house, so that the true owner can claim it back. That's equally fine. However, no one claims back the mobile phone. Okay. So after some time, Ajay goes to Bijoy, the manager, and he requests him to return the mobile phone to him. Okay. So on Bijoy's refusal, Ajay files a suit against him for the recovery of the phone. Okay, this gives me an idea. He is finding a mobile phone. So ये है क्या? The locker point that hits me. Is it a finder of good? And the moment he is a finder of good, he becomes daily of the goods. The moment he is a finder, he becomes daily of the goods. तो इसका आंसर क्या लिखेंगे? Let's see that. Yes, yes, Ajay will succeed. फिर हम law discuss करते हैं. So you can write the conclusion पहले और then you can write the law. That is, according to Indian Contract Act, liability of a finder of goods belongs to someone else is that of a baby. Okay, you write down is that of a baby. He must take care of the goods as a man of ordinary prudence could. So if he is a man of ordinary prudence, he has to take care of the goods. He must also not appropriate the goods to his own use. That's equally clear. And if the real owner is traced, he must retain the he must return the goods to him, and is entitled to the reward. Okay, and is entitled to the reward that may have been offered by the owner. So if the owner has kept a reward, then he can definitely ask for it, or the owner at his free will can give the rewards. अगर उसने कोई rewards रखा है तो owner दे सकता है, नहीं तो just the return of the property. He is also entitled to retain the goods against the owner till he receives the compensation. हाँ, उसने अगर कुछ खर्चे किए हैं, so to claim the compensation, he can retain the goods even against the owner. So in the given case, Ajay can recover the mobile phone from Bijoy because he is entitled to the possession of the goods as against the whole world except the true owner. So he can recover, he can retain the goods as against the whole world and also the, but except the true owner. तो ये देखा आपने आंसर कैसे लिखा. आपने पहले यस से स्टार्ट किया, फिर आपने प्रोविजन और जो फैक्ट्स है उसको किस तरीके से एनालाइज करते हुए डिस्कस कर दिया. फाइंडर ऑफ द गुड्स, सो इजीली. ओके, नेक्स्ट वन. Second is Baiju is a singer. He enters into a contract with Alok, the manager of a theater. Okay, so he enters into a contract to sing at his theater 3 nights every week during the next 3 months. That is equally fine. And Alok promises to pay 5,000 each night's performance also. That's fine. That's the terms of the contract. On the 7th night, Baiju willfully absents himself from the theater. Oh. So now there is a breach of performance coming into it. Can Alok put an end to the contract? So when one party breaches the performance, can the other party put an end to the contract? You know it. Okay. So write down, yes, Alok is at liberty to put an end to the contract. वो अपनी मर्जी से contract को end कर सकता है. And as per section 39 of the Indian Contract Act, when a party has refused to perform or is disabled himself from performing his promise in the entirety, the other party may put an end to the contract unless he has signified by the words or conduct his acquiescence to the continuance. That is section 39 बहुत clear है. Say one party is refusing to perform the contract. He says, I'm disabled to perform the contract. Okay, he is disabled. So can the other party put an end to the contract? Yes, he can. Unless there has been clear terms, अच्छे से लिखे हुए terms, whereby you put that I consent that आगे भी मैं आऊंगा. So unless those are terms clearly stated, you can put it into a contract where the performance is not happening. So यहाँ पे, in the given case, Baiju willfully absents himself from the theater, Alok can resign the contract. He can validly resign the contract. Okay, let's say Amod has, so that was second one. Now third one. Amod has authority from his principal Binod. Okay, so if the Binod is a principal, so Amod is the agent to sell the goods on credit. Okay, Amod, the agent, sells the good on credit to Chandan, the buyer, without making a proper and usual inquiry as to Chandan's insolvencies or solvencies. Okay. At the time of such sale, Chandan was insolvent. Okay. मतलब एजेंट ने गुड्स बेच दिया और जब ये गुड्स बेचा जा रहा था at that particular point of time the buyer was insolvent, so the agent did not do his duty properly. Yeah. So should Amod compensate Binod? That was December 2008 ka question for 5 marks. Okay, you can discuss section 212 in detail if you want to, but the answer is yes. Yes, Amod has to compensate Binod because as per 212, it is one of the duties of the agent to work with reasonable skill, diligence, whereby the nature of the profession so require. So many people ask me, sir, do we have to write lengthy answers like 5 marks ka so much? See, the content is important and is it to the point? यहाँ पे question से इतना पूछा है, should Amod compensate? And आपने बोला yes, Amod has to compensate. Why? You explained that why as well. Section 212 says that it is the duty of the agent, okay, to work with a reasonable care and diligence, and he did not do so, so he has to compensate the principal. So that is more than sufficient. But if you still want to put your agency related knowledge, indefinitely put it. Okay, so that was third question tackled. Let's see the fourth one. Fourth one is there was an agreement to lend 5 lakhs to Bimla in consideration of her getting divorced and marrying Govind. Oh, now that's against enforceability of law. The lender. Is the agreement enforceable? Well, December 2008 ka tha. The answer is clearly no. See, the agreement is not enforceable at all. Not at laws at all. It's not enforceable at all. Why? Section 23 of the Indian Contract Act, whereby an agreement of which consideration is unlawful, and this consideration is unlawful. You are asking a valid marriage has to be destroyed. So the consideration is unlawful against the public policy. Then such kind of agreement is void. And in the above case, an agreement to procure a marriage for a reward itself is void. It's opposed to public policy. Okay, so that's where you put your answers. You give the answers no, and then you give the explanation. That's also fine. Okay, now let's see the fifth one. What is the question that have been put to us? In the fifth one, Amar offers by advertisement a reward of 1,000 to anyone who returns his lost bag. Bahadur finds the bag and brings it to Amar without having the knowledge of the offer of reward. Is Bahadur entitled to reward? Okay, this has been one of the favorite questions. So June 2009 mein tha, if a person is not aware of the offer, he cannot accept the offer. You cannot give acceptance to the offer before the offer is known to you. Okay, so the answer is no. And how you write it? You can write it this way. Bahadur is not entitled to reward according to Indian Contract Act. And please don't write short forms, sir. According to Indian Contract Act, this is the short form, IC Act. IC Act. So ऐसा करके short forms please avoid करो. This is not a good practice. Please avoid short forms. Write it properly. Okay. So according to Indian Contract Acts, okay, an offer is effective only. Okay. An offer is effective only when it is communicated to the offeree. So when you have communicated, when you have discussed with the offeree, then it's effective. So unless the offer is made known to the offeree, there can be no acceptance and hence no contract. जब तक आपने offer disclose नहीं की, there can be no acceptance and there can be no contract. The fact of the case is similar to Lalman Shukla versus Gauri Dutt, and this was one of the favorite questions of institute, where it was decided that the proposal must be communicated to the offeree. So दैट वे आपने केस लॉ भी साइड कर दिया, अपने लॉ भी बता दिया और अपने आंसर्स भी दे दिए. Okay, see the manner we put it. Let's see the sixth one. Okay, sixth one. Avdesh contracts to sell piece of silk to Bhupesh. Bhupesh thinks it is Chinese silk. Okay. Avdesh knows that Bhupesh thinks so, but Avdesh knows that it is English silk. Oh, the seller is aware that it is English silk. Avdesh does not correct the Bhupesh impression. Subsequently, Bhupesh discovers it is not a Chinese skill. Can he repudiate the contract? And the answer is no. The buyer be aware. Caveat emptor. अब सर ये तो सेल ऑफ गुड्स एक्ट का था. एक्चुअली क्या था, पुराने कॉन्ट्रैक्ट एक्ट के क्वेश्चंस में कभी कभी सेल ऑफ गुड्स एक्ट, कभी कभी स्पेसिफिक के क्वेश्चंस रिपीट हो जाते थे. तो इसलिए वो क्वेश्चन जब रिपीट हो जाते थे तो हमने उसको भी टैकल कर लिया. तो यहीं पे थे. तो इट वाज एक्चुअली फ्रॉम अ सेल ऑफ गुड्स एक्ट, एंड डोंट वरी, यू हैव सेल ऑफ गुड्स एक्ट इन योर course. So the answer is no, Bhupesh cannot repudiate the contract. Bhupesh cannot repudiate the contract. The rule of caveat emptor applies when the purchaser buys the goods. ठीक है, पहले ये लिखा. फिर आप नेक्स्ट लाइन पे लिखते हो, no, Bhupesh will not succeed according to section 16 of Sale of Goods Act. Now you write the relevant section. According to section 16 of Sale of Goods Act, the principle of caveat emptor applies when the purchaser buys the goods. When the purchaser buys the goods. It is not the seller's duty to give the buyer goods which are fit for suitable purpose. देखो, बायर कौन से गुड्स खरीदा है वो बायर की चॉइस के हो. सेलर नहीं बताता आपको ये सूटेबल है कि नहीं. सेलर पूछता है आपको क्या चाहिए और आप उसके हिसाब से वो गुड्स देता है. आपको सूटेबल है कि नहीं वो आपकी चॉइस है. So it is the purchaser who has to decide whether the particular goods are fit for his or her consumption or for use. Okay. So यहाँ पे continue, which are fit for the suitable purpose of the buyer. In fact, the buyer must satisfy himself that they are fit for that purpose. In the given case, Bhupesh himself made the selection without depending on the skills and the judgment of the seller. He has not even relied on the skills and judgment of the seller. Okay, he himself is responsible despite the fact Avdesh has remained silent, and therefore Bhupesh cannot avoid the contract. जो जानता था, Avdesh जानता था, लेकिन the buyer never asked for it. So why should I give you explanation? That's what it is. Clear? तो यहाँ पे ये पॉइंट अपने आप में क्लियर हुआ. नेक्स्ट क्वेश्चन देखिए, सेवेंथ वन. Amrit's wife Barkha paid 5,000 to Chandan to give as a bribe to a jailer for procuring the release of her husband from jail. Okay. The jailer failed to procure the release. Can Barkha recover the amount? The answer is no. It's June 2009 ka question. Absolutely no. Barkha cannot recover the amount as the agreement is void and opposed to the public policy. It's clear. If these kind of agreements are opposed to public policy, it's a void agreement, it's opposed to public policy. This section 23 of the Indian Contract Act. कैसे आंसर लिख रहे हैं? Section 23 of the Indian Contract Act. An agreement of which the consideration is unlawful or against the public policy is void. Okay, unlawful consideration करके पढ़ा. An agreement of which the consideration is unlawful or against public policy is void. That's how you explain it. So simple. Okay. Eighth one. Amar advanced a loan of 50,000 to Baljeet, and Sumit promises to Amar that if Baljeet does not pay the loan, then he will do so. Who is a principal debtor? Who is a creditor? Who is? The question says that Amar advanced a loan of 50,000 to Baljeet. तो अमर ने लोन दिया है. ओके, तो अमर इज अ क्रेडिटर, बलजीत ने लोन लिया है, इज अ डेटर. ओके, एंड सुमित प्रॉमिसेस टू पे, ही इज अ श्योरिटी. दैट स्पीक्स. अब देखो इसको लीगली कैसे लिखना है. द कॉन्ट्रैक्ट इन द क्वेश्चन इज ऑफ अ गारंटी एज पर द इंडियन कॉन्ट्रैक्ट एक्ट. द पर्सन हु गिव्स द गारंटी इज कॉल्ड द श्योरिटी, एंड द पर्सन for whom the guarantee is given is called the principal debtor, and the person to whom the guarantee is given is called the creditor. So first you explain the contract of guarantee and then you write down. In the given case, Baljeet is the principal, Amar is the creditor, Sumit is the surety or the guarantee. Okay, so that is as simple as this one. Okay, ninth one. Suresh, an agent, has the authority from his principal Bhupesh to sell the goods on credit. Okay, Suresh sells the goods on credit to Chandan without making proper inquiries about the Chandan's financial status. Hey, it's a repeated one. अभी ऊपर पड़ा था. Similar question has been coming. So at the time of the sale, Chandan was insolvent. Is Suresh liable to compensate the principal? Yes. Yes, Suresh is liable to compensate the principal according to section 212 of the Indian Contract Act. One of the duties of the agent that he must work towards the reasonable skill and diligence, which is actually by his very profession. Okay, तो हर एजेंट को ड्यू डिलिजेंस एंड diligently काम करना चाहिए. So in the given case, Suresh sells the goods on credit to Chandan without inquiring about the financial position, which a man of ordinary skills will not do so. So Suresh is under obligation to compensate the principal, Bhupesh. Okay, so that way you can put up the answer. It's repeated. So sir, questions do repeat. Yes, they do. Especially contracts, the chances are there. 2010, another one. Raman purchased a pastry from standard pastry shop. It contained a piece of stone which broke one of Raman's teeth. What remedy has Raman against the shopkeeper? I believe it's Sale of Goods Act again. Sale of Goods Act. Okay? Because wholesomeness and fitness of the goods, that is the question. So Raman can sue. देखो आंसर लिखे Raman can sue for the damages against the pastry shop. You can sue. But according to section 16 of the Sale of Goods Act, there is an implied condition as to wholesomeness. The goods has to be wholesome. The goods has to be fit for consumption. This means the goods must not only be as per the description, but has to be wholesome and they have to be sound. In the given case, Raman purchased a pastry from the shop which contained a stone resulting in the damage to his tooth. That amounts to breach or implied condition which existed on the part of the seller, and such seller must be held liable. That speaks for itself. That was question number 10. Okay, let's see question number 11 now. What does the question number 11 say? 11 says, Anil gives a guarantee to Kamal in January for supply of goods worth 10,000. Okay, to Vimal on credit. Okay, so Anil is a guarantor. Okay. The payment was to be made in April as per the terms. However, Vimal made the payment in the month of March itself. Oh, the payment is already made. And again took the goods on credit from the credit basis from Kamal for the same amount but failed to pay. अच्छा पेमेंट करने के बाद फिर से गुड्स लिया. Okay, now Kamal files a suit against Anil for the payment. Will Kamal succeed? It's clearly no, because unless it is a continuing guarantee. Let's see. So answer में पहले क्वेश्चन पढ़ के समझ में आया, is it a continuing one? Absolutely no, it's a specific one. ये बिल के अगेंस्ट में इतने की गारंटी देता हूँ, वो बिल की तो पेमेंट हो चुकी है. तो जब वो बिल पे हो चुका है तो वेयर इज अ क्वेश्चन ऑफ गिविंग यू फर्दर मनी. गारंटी इज ओवर, इट्स रिवोक्ड. तो यहाँ पे कमल विल नॉट सक्सीड. आप लिखोगे सेक्शन 129 इंडियन कॉन्ट्रैक्ट एक्ट. A continuing guarantee. The continuing guarantee is one which extends to a series of transactions, and a specific guarantee is given to for a single debt, and it comes to an end when the debt has been paid. When the debt has been paid. So in the given case, Anil gives a guarantee to Kamal, which is a specific guarantee, and it comes to an end when Vimal made the payment in the month of March. तो मार्च महीने में उसने ऑलरेडी पेमेंट कर दी थी. So thereafter, whatever Kamal has supplied to Vimal is without any guarantee, absolutely without any guarantee. Correct or not? Hence, Kamal will not succeed. It speaks for itself. How can he be succeeding? Okay, that's 11th one. Let's see the 12th one. Mohan is a singer, agrees to sing at Twinkle's theatre for a certain period. He further agrees that during the prescribed period, he will not sing at any other theatre. Okay, fine. Afterward, Mohan makes a contract with Sohan to sing at his theatre during the period and refuses to sing at Twinkle's theatre. Okay, what remedy Twinkle has got? So यहाँ पे देखो, one party who has done a contract and he is breaching the contract, or this contract has two terms. ये actually specific relief का question है. स्पेसिफिक, जैसे मैंने बोला था पहले, इंडियन कॉन्ट्रैक्ट एक्ट में कभी कभी सेल ऑफ गुड्स एक्ट एंड स्पेसिफिक मर्ज हो जाते थे. ये उसका है. व्हेन द कॉन्ट्रैक्ट हैज टू पार्ट्स, वन इज कॉल्ड अफर्मेटिव पार्ट एंड वन इज कॉल्ड नेगेटिव पार्ट, एंड इफ द अफर्मेटिव पार्ट कैन नॉट बी एनफोर्स्ड, देन द नेगेटिव पार्ट ऑफ द कॉन्ट्रैक्ट may be enforced. Okay, that's what we can write it in the answer. So Twinkle can file a suit against Mohan claiming the injunction from the court. That's true. That is an order restraining a person from doing a particular act which he promised not to do. Okay, तो इस केस में ये डिपेंड करता है कौन सा केस कौन से नेचर में जाएगा. यहाँ पे सामने वाले को हम रोकने की बात करें, टू डू अ पर्टिकुलर एक्ट विच ही हैज प्रॉमिस्ड दैट ही विल नॉट डू दैट. ओके, so the court in its discretion, it's a court in its discretion to enforce the negative part of the contract. That's what I'm saying. When the contract has two parts, one is positive, one is negative, you can always enforce the negative part if the affirmative part cannot be enforced. So as decided in Lemmy versus Weger, specific relief act cannot be granted to the plaintiff, but wrongful commission can be prevented. You cannot be giving a specific relief to the plaintiff, but you can always prevent some kind of commissions. Okay, so that was question 12. Now you can see question number 13. Sandeep, a jeweler, deals in artificial jewelry. Sandeep sells his business to Kuldeep and also charges for the goodwill. Sandeep further agrees to Kuldeep that he will not do the business in artificial jewelry, as well as real jewelry within the local limits for a certain period of time. Okay, you can give assurance, you can give when you sell the goodwill, ये बात ठीक है, you can give assurance कि मैं एक particular nature of business नहीं करूँगा, but you cannot give assurance कि मैं कोई और दूसरा business भी नहीं करूँगा. That is a restraint on business of profession. So, which is the contract valid? It speaks नहीं. So हम कौन सा section side करें? Section 27. So Section 27 Indian Contract Act, every agreement by which one party is restrained from exercising a lawful profession, business or trade of any kind, to that extent is void. But the exception to the rules that where a seller of a goodwill of a business undertakes not to compete with the buyer is enforceable. That's true. एक अगर goodwill बेचा गया तो you can always enforce that part of the contract कि आप में से competing business नहीं करोगे. That's true. Enforceable. When the restraint appears to be reasonable as to the territorial limits and length. That is, reasonability as to the length and reasonability as to the limits has to be there. In the given question or in the given problem, the contract is valid only for the part which is concerned for the artificial jewelry. That's correct, because he has bought a business of artificial jewelry. But that will not be valid for dealing in the real jewelry, as the restraint for trading in the real jewelry was absolutely unreasonable regarding the nature of the business. So same decision was taken in the Gold Soul versus the Goldman case also. Okay, so is that clear? Okay, now let's see the other one. In this case, Ram wrote to Sham to sell his apples at 150 per kg. On the same day, Sham wrote to Ram to buy the apples at 150 per kg. Oh, one party writing to the other one, other party writing to the former one. It's a cross offer. Yes, their letters cross and post. So Sham now requires Ram to sell his apples as there was enforceable contract between them. Okay, does it amount to a contract since both the party was giving the same amount? The answer is no, it's a cross offer. So the answer is no, Sham will not be able to enforce the contract. In the given case, Ram and Sham made identical offers, ignoring each other offers, which means there is neither valid offer nor valid acceptance and no consensus addendum. देखो इस तरीके से आपको आंसर लिखना है. And these are called cross offers and there is no completed agreement. Hence, there is no binding contract. It's short, but that's how you have to be precise. Okay. The next one, 15th one. It says that Roni, as a doctor, by exercise of undue influence, persuaded Yana, his patient, to sell a valuable gold watch to him for 500. Roni obtained the possession of the watch and he pledged it with Kapil. Is it a valid pledge? देखो अगर यहाँ पे जो undue influence हुआ है उसकी रिपोर्ट कर दी जाए या उसको रोक दिया जाए, then things would have been different. लेकिन प्लेज करने के पहले होना चाहिए, प्लेज करने के बाद नहीं. अगर प्लेज करने के बाद हुआ तो प्लेज वाज वैलिड. ओके, क्या बोला? So the answer is yes, the pledge is valid. लॉ क्या बोलता है? According to the provisions of the Indian Contract Act, the person in possession of the goods may pledge the goods before the contract is avoided by the other party. So Ronnie is a doctor who has got the things from Yana, the watch. Now in that case, अगर याना ने उस वॉच के बारे में पुलिस कंप्लेन कर दी, उसके बारे में नोटिस दे दिया, तो थिंग्स वुड हैव बीन डिफरेंट. लेकिन उसने ऐसा कुछ भी नहीं किया था अभी तक. ओके, ऐसा क्वेश्चन में तो नहीं लिखा. So and the pledgee can get a better title. Okay. So in the given case, pledge is made by Ronnie is a valid pledge if Kapil has acted in good faith without notice of the pledger's defective title. So he should have acted in the good faith as the person of a knowledge without notice of the title. Okay. Let's say the 16th one, 15th one was also a simple one. Arun's wife Bipasha paid 15,000 to Vipin to give as a bribe to the jailer. Oh, it's a repeated one. Procuring a release of her husband from the jail. The jailer failed to procure the release of. Can Bipasha recover the amount? The answer is no. It's against public policy. A repeated question आया था again 2012 June में. So you know काफी questions repeat हो रहे हैं. Okay, so that give you an idea कि अच्छा इस तरह से question repeat भी होते हैं. ठीक है. Then X 71 X promised to pay 10,000 per month to his wife Mrs. X who was living in Mumbai. On receiving the information that she was unfaithful to him, he stopped paying 10,000 to Mrs. X. Mrs. X approached you to file a case against X. Advise her. Can she file 2013? No. It's a social contract. It's a contract of a general nature. हर कॉन्ट्रैक्ट के ऊपर आप केस नहीं कर सकते. हर एग्रीमेंट कैन नॉट बी प्रोसिक्यूटेड और सूड. नहीं तो फिर दुनिया भर के केसेस आ जाएंगे. इट हैज टू बी ऑफ अ कमर्शियल नेचर. It has to be a promise in form of an agreement which has enforceability of law or legal recognition. Okay, तो इसका आंसर कैसे लिखना है? Indian Contract Act does not cover contracts of personal nature. That is, the agreements between the husband and wife are social agreements, and social, religious, moral agreements do not create binding legal relationships. They are beyond the scope of Section 10, which specifies the requirements of a valid contract. Hence, in the case given, Mrs. X cannot file a case under the Act against Mr. X for the non-payment of 10,000 to her every month, since the agreement is not intended to be a legal relationship. Clear? तो देखो कैसे एनालाइज करके आपके आंसर्स आ रहे हैं. आप बता रहे हो एक सोशल एग्रीमेंट है, रिलीजियस नेचर का है, it has no legal relationship, it is beyond the scope of Section 10 also, and then you're giving the facts, blending it with a question how it cannot be enforced. Okay, that's unique way. That's the way you put it. Okay. So now we see the 18th one. 18th one says X and Y are husband and wife, and respectively by a registered document after referring to several quarrels and disagreement between himself and his wife, Y promised to pay his wife a sum of money of her maintenance and separate residence. Whether the document is a contract enforceable, it's just a repetition. ये देखो December 13 and December 15 का just a repetition है. It was a famous case of Rajlukhi Dev versus Bhutnath Mukherjee. The Hindu husband, by a registered document after referring to the quarrels and disagreements between husband and wife, promised to pay his wife a sum of money for the maintenance and separate residence. It was held that these promises are unenforceable since natural love and affection was missing. It's a social contract. And in the above judgment, it was said that the document in question is not a contract enforceable by law as natural love and affection is missing. So it's not even a gift. Okay, fine. 19th one. Why a young boy ran away from his father's home. His father issues a pamphlet offering a reward of 5 lakhs to anybody who would bring the boy home. Arun saw at the railway station and sent an email to the boy. Okay, email. So catch. He usko email पता कैसे? Is Arun entitled for reward? And in the light of the above case, explain the governing offer. See, this is the nature of general offer. ये बात तो एकदम क्लियर हो गई, बट उसको ईमेल कैसे पता चला? इसका मतलब उसने पैम्पलेट पढ़ा था. बिना पैम्पलेट के उसको ईमेल कैसे पता चलेगा यार किसी का? तुम्हें ईमेल किसी का पता चल सकता है क्या जब तक तुमने पैम्पलेट नहीं पढ़ा हो? That's the point. So this is a similar case of Harbhajan Lal versus Harchan Lal. In the given case, if you remember the case, तो ही लिखना, नहीं तो one of the recent case, one of the landmark case लिख सकते. A young boy ran away from his father's home, and the father issued a pamphlet offering a reward of 500 to anybody who bring the boy home. The plaintiff saw the boy at the railway station, and he sends a telegram to the father's spot. It was held that the pamphlet was an open offer to the world at large and was capable of being accepted by anyone who fulfills the conditions contained in the offer. That's interpretation. So the plaintiff substantially performed the contract and was entitled to the reward. Okay, that's what it is. So the only condition is that the claimant should have the knowledge of the offer, as what has Carlyle versus Carlyle Smokewell Company. So it's a great case. If you have the knowledge of the offer, then you can accept the offer. That simple it is. So in the case mentioned, Arun saw the boy and he emailed the father. We can safely assume that he has full knowledge of the offer, since he could not have known the email address except from the pamphlet. See, it speaks for itself. Okay. तो आप detailed discussion भी कर सकते हो, आप अच्छे से brief में भी explain. Next, see the next one. 20th one. A invites B to stay with him during the winter vacation at his residence. Okay. B accepts the invitation and he informs A accordingly. Okay. When B reaches A's house, he finds it locked. Oh, winter में घर बंद था बेचारा, and he has to stay in a hotel. B can claim damages from A. Can he claim damages? Okay, good one. The answer is no. It's a social contract again. It's a personal nature. Dosti या दोस्ताना का contract, something like that. So B cannot claim damages from A. See, invitation to stay with A is an offer that leads to a social contract. That's it. And that's how you frame the answers. So social or domestic contract is not at all enforceable. Similar agreement between two persons to go together to cinema or for a walk or something of a similar nature, that is a social and a personal nature, does not create a legal obligations on their part to abide. So social contract cannot be enforceable, because ये शुरू कर दूं तो हर contract कल को litigation हो जाएगा. So there cannot be an offer and acceptance to the hospitality leading to contract. Okay? हाँ, अगर होटल के अंदर रूम बुक किया होता और होटल ने रूम बुक नहीं दिया है, ऐसा कुछ होता, things would have been different. ठीक है? Let's see 21. Aman hired a room in a hotel. So we were just discussing about a hotel. होटल आ गया. And paid a week's rent in advance. After registering, he went up to occupy the room. Aman found a notice on the wall that the proprietor will not be responsible for the articles lost or stolen, okay, unless handed over to the manager of the hotel for the safe custody. Okay. Now, owing to the negligence of the hotel staff, the thief gained access to the room and stole some goods of Aman. Oh. State whether the proprietor of the hotel is liable for the loss? Yes, because when you are entering into the contract, नीचे reception पे लिखा होना चाहिए कि you have to take care of your own goods. The hotel will not be responsible for any kind of loss. Room में जाके लिखा होगा, that could be additional notice, but that not is the notice. So as per the condition of the validities, as per the Indian Contract Act, let's explain this. Any condition pertaining to the contract to be entered should be given before or at the time of the contract. आपको पहले बताना चाहिए ना, बाद में नहीं. If they are given subsequently, that is, after the parties have already contracted, they do not bind the parties, since he did not know of them when he agreed to the contract. So he was not even aware that this was a condition. Hence, a subsequent notice about the conditions will not be binding on the other party. Okay, so ये हमने law put up किया, and let's see. In the given case, the proprietor of the hotel was liable to pay loss since the terms of the offer was communicated after the acceptance. Hence, the term was not the part of the contract and was not bound by them. It is an oral contract on performance. As simple as this. Okay. Next one. A agreed to supply B certain goods. Okay. So 22nd, A agreed to supply B certain goods to be procured from Indonesia. The goods could not be procured due to riots and civil disturbances in Indonesia. Whether the non-performance can be excused? No, not at all. अगर देखो सुपर विनिंग कॉन्ट्रैक्ट क्या होता है कि जब एक्ट ऑफ गॉड हो और नहीं कर पाए तो ठीक है, लेकिन अगर राइट्स है, अगर सिविल डिस्टर्बेंसेस है तो ओके, दैट इज अ फेज, दैट कुड बी टेम्पररी, दैट कुड बी समवेयर। और ऐसा नहीं है कि आप पूरी तरह कॉन्ट्रैक्ट ही खत्म कर दो। स्ट्राइक अभी है तो यू कैन डिले द कॉन्ट्रैक्ट बट येट यू कैन कंप्लीट द कॉन्ट्रैक्ट ना। ओके, इट्स नॉट सुपर विनिंग इम्पॉसिबिलिटी, समथिंग लाइक अ कोविड सिचुएशन के मैं कुछ नहीं कर पा रहा। ओके, so the problem is related to a discharge of the contract due to supervening impossible. Ordinarily, a person undertakes to do something he must not do unless the performance becomes subsequently impossible. Okay, due to any of the circumstances under Section 56 of the Indian Contract Act. You should not be agreeing to something that you cannot do. Okay, a contract is not discharged by mere fact that it has become more difficult to performance due to some uncontemplated events or delays. Just because it is difficult to perform, you cannot cancel a contract. Something like strikes, lockouts, civil disturbances like rights, they do not terminate the contract. Exactly, they do not terminate the contract. So unless there is a clause specifically in the contract providing for the non-performance of such cases, okay, so if you have agreed specifically तो आप ये cancel कर सकते हैं, but if you have not agreed you cannot be cancelling that. In the instance case, the problem is related to the events of strikes, lockouts, civil disturbances which do not discharge a contract because the parties to the contract have not specifically agreed in this regard at the time of formation of the contract. अगर आपने agree ही नहीं किया तो how can you put these clauses and cancel a contract? You cannot. As per the agreement, the goods could not be produced due to rights and civil disturbances in Indonesia. Hence, there is no excuse for the non-performance of the contract. Got it? That's the way you can put your answer. Okay. Now, next question. What is the next question? Question 20. Mr. X, in consideration that Mr. Y will employ Mr. Z in collecting the rent of zamindari, promises to be responsible to the amount of 10,000 rupees for the due collection and payment to Mr. Z on these rent. Whether it is a contract of guarantee, yes. Which type of guarantee? Mostly continuing. When such guarantee can be revoked? Interesting. In fact, ये बहुत पुराने टाइम का एक प्रथा थी, एक कल्चर था, एक प्रैक्टिस थी। इसको हम लोग जमींदारी सिस्टम बोलते थे, जिसमें हम लोग लोगों को एम्प्लॉय करते थे, ओके, कलेक्शन के हिसाब से। सो देखो, ऐसा है कि एक मिस्टर एक्स आया और उसने मिस्टर बी को बोला कि देखो मेरे जान पहचान का एक लड़का है, बहुत अच्छा लड़का है, मिस्टर वाई, ये वाई को तुम अपने उधर कहीं काम पे लगा दो और ये रेंट तुम्हें कलेक्ट करके दे देगा। तो मिस्टर बी ने बोला, भाई इसकी जवाबदारी कौन लेता है? हु टेक्स द गारंटी, हु टेक्स द ऑब्लिगेशन? तो एक्स ने बोला, मैं लेता हूँ, 10,000 रुपये तक की इसकी जवाबदारी मेरी, अगर इसने कुछ भी गड़बड़ की मैं आपको 10,000 दे दूँ। तो मिस्टर बी ने अपने एक एम्प्लॉय जेड को बोला, भाई एक काम करो, वाई को एम्प्लॉयमेंट दो, ओके, और मिस्टर एक्स को बोला कि आप हमें गारंटी दो, कब तक? जब तक भाई मिस्टर वाई को हम अपना परमानेंट एम्प्लॉय नहीं बना लेते तब तक आपकी गारंटी रहेगी। बात तो ठीक है, बात अच्छी भी है। तो ये नेचर था पहले के जमाने का, बहुत पहले के टाइम पे ऐसा होता था, ठीक है। सो उस चीज को बहुत सुंदर तरीके से, वेरी ब्यूटीफुल क्वेश्चन दैट हैज बीन फ्रेम्ड फ्रॉम दिस वन, ओके। So let's see what answer that we can write. The contract of guarantee may be from the existing debt or from the future debt. Perfect. It may be specific guarantee or it may be a continuing guarantee. A specific guarantee is given for a single debt and comes to an end when the debt guaranteed has been paid. Okay. A continuing guarantee is one which extends to a series of transactions as per 129. ये आपने समझा दिया. The liability of a surety in case of a continuing guarantee extends to all the transactions contemplated until the revocation of the guarantee, until it's revoked. Okay. As for instance, X, in consideration that Y should employ Z in collecting the rents of zamindari, he promises B to be responsible to the amount of 10,000 for due collection and payment to Z of these rent. Okay, हमने क्वेश्चन को suitably डाला. This is a continuing. और क्वेश्चन समझ में आया कि मिस्टर बी को बोला बी बहुत बड़ा जमींदार है, ये एक जमींदार है. तो सर एक लड़का है मिस्टर एक्स को वाई को जरा एम्प्लॉय कर लो, अच्छा आदमी है, तो दैट विल हेल्प हिम एंड अस, और मैं इसकी जवाबदारी लेता हूँ. So this is a continuing guarantee. It can be revoked in 3 situations. Okay, some of the situations, rather 2 situations. One is called notice of revocation by the surety. जहाँ पे notice देके, a notice operates to revoke the surety's liability as regards the future transaction. Exactly. He continues to remain liable for the transactions entered prior to the period of notice. That's true. And second is by death of the surety. The death of the surety operates in the absence of the contract as a revocation of the continuing guarantee, as far as the future transactions are concerned again. But for all the transactions made before the death, surety's liability always remains. वो सिर्फ surety के estate से recover की जा सकती थी. Okay? अभी next वाला देखते हैं. 24. John, who is known minor. Oh, जाना माना minor. John, who is known minor, fraudulently overstates his age and takes the delivery of motor car after executing a promissory note in favor of a dealer for its price. तो जॉन ने एक गलत promissory note execute किया है in the favor of the dealer. He does not knowingly honor his promissory note. जानता था. Okay, and that is to say he does not pay the price of the said motor car. What is the remedy available for the motor car dealer? इसको हम लोग एक तरह से specific relief act से देख सकते हैं क्वेश्चन को, because इस केस में right of restitution आता है against a minor. मतलब अगर वो मोटर कार अभी भी माइनर के पास है तो कार रिकवर कर सकते हैं. I cannot make a minor liable for a contract. I agree, but at least I can recover the property. That's called right of restitution against the minor. Okay, यहाँ पे minor आंसर लिखते हैं. A minor is not bound by the misrepresentation. That's correct. If a minor procures a loan or enters into any kind of agreement by representing that he is of a full age, he cannot be prevented from pleading his minority in his defense. That's true. He can always plead. Okay. He will not be held liable under the contract. That's correct. It was held in Sadiq Ali Khan versus Jay Kishore that deed executed by a minor is nullity and there can be no estoppel against the statute. So minor की deed अपने आप में एक nullity है and that cannot be enforced. However, it does not mean that the minors are allowed to cheat and to enjoy the fruits of their frauds. So it does not mean कि minor कभी भी किसी को भी cheat कर सकता है और कुछ भी पैसा लेके जा सकता है. No, not that way. According to section 33 of the Specific Relief Act, that's what I'm saying, ये section है. The court will order on equitable consideration for restitution if the minor is still in the possession of the money. तो अगर minor के पास वो money, वो things अभी भी है, that can be recovered. Okay. The minor shall have no liability of if the money or the thing cannot be traced out of it. हाँ, अगर रिकवरी नहीं होती तो बात अलग है, लेकिन रिकवरी हो सकती है तो हम जरूर रिकवरी करेंगे. अब इसका नेक्स्ट क्वेश्चन देखते हैं, 25th वन. तो एज यू कैन सी काफी वैरायटी ऑफ क्वेश्चन से काफी कुछ समझ में आया. जून 2018 का क्वेश्चन था. Gemaxo Limited offered a reward of 10,000 by an advertisement to anyone who infected influenza after using the smoke ball in the specified manner. Mrs. Upma uses the smoke ball in the specified manner but still infected by influenza, and she claims the reward. Decide with the help of the leading decided case law and related sections. So it's a clear-cut case of Carlyle versus Carlyle Smoke Ball Company, जहाँ पे general offer can be accepted by any person who is aware of the knowledge or who has the aware of the offer and fulfills the condition of the offer. So let's write down the facts in the questions are based on a landmark judgment, Carlyle versus Carlyle Smoke Ball Company. In this case, the court held that general offer is one which is not made to a definite period but to the world at large or the public in general. Perfect. A general offer can be accepted by any person by fulfilling the terms of the offer. That's pretty clear. As a general offer, the contract is made with the person who have knowledge of the offer and comes forward and acts according to the conditions of the offer. So he or she has the knowledge and he accepts the condition. In given case, Mrs. Upma used the ball in the specified manner. Perfect. It amounts as in accepting the offer, fulfilling the terms of the offer. Yes, she has accepted the offer. She fulfills the term. Consequently, valid contract is formed between her and the company. And now she is entitled to recovery the same because she has accepted the offer by fulfilling the terms of the offer. She will be successful. She will be. Okay? Samjha? She will be successful in this case. Now, ABC company. Let's see the other one. ABC company offered by advertisement a reward of 1,000 to anyone who contracted influenza by using the smoke ball in the specified manner. Amrita used the smoke ball in the specified manner, but she was attracted by influenza. He filed a suit against ABC and claimed the reward. It's like June 18 में उसी topic पे question, December 18 में same topic के questions. Exactly. It's also the question of Carlyle versus Carlyle Smoke Ball Company case. You can discuss a similar judgment and then write down the facts. Okay. So great. ऐसा होता है exam में कभी कभी. Ram, employed in Mumbai, promised to pay 8,000 per month to his wife Sunita. She was living in Delhi. On receiving the information that she has become unfaithful, Ram stopped the payment to Sunita and Sunita approaches to file. Again, a matter of social contract, social agreements cannot be. Okay. So again, ऊपर वाला आप answer देख सकते हो. And A advertises in newspaper that he will pay 1,000 to anyone who brings him his lost son. B, without knowledge of his reward, finds A's lost son and restores. Can be a claim for the reward. You cannot accept the offer. Same Lalman Shukla versus Gauri Dutt. And C, December 2019, one of the few of the latest papers यहाँ पे ये आया है. Okay, so यहाँ पे ये आया है. See the question that has been cased. Okay, so and in the given case, B did not know of the reward. He cannot claim for the reward. सेम वही फैक्ट्स है, उस चीज को रिपोर्ट किया. Okay, let's see the other one. Avanti took a motor car insurance from Healthy Trip Insurance Company. The check was issued under the contract of insurance of the motor car issued by the insured for the payment of the premium of the policy. Okay. However, the check was dishonored. Oh, he issued the check of the premium वो dishonored हुआ था. वैसे तो ये वाला हमने कंज्यूमर प्रोटेक्शन में भी देखा था, लेकिन कंज्यूमर प्रोटेक्शन में देखने के बाद उसमें भी कॉन्ट्रैक्ट का क्वेश्चन था, इसलिए यहाँ पे भी पुट अप किया हुआ है. लेट्स सी दिस. So she issued the check and that check was dishonored. Meanwhile, the car met with the accident and badly damaged, killing the insured owner. तो कार ने एक्सीडेंट हो गया और इसने बुरी तरह उस पर्सन को डैमेज किया हुआ है. तो अब इसमें यही होगा. The claim of the insured was repudiated. वो तो होना ही था. Decide whether the contract of insurance has been performed. Analyze the provisions of Indian contract in respect and whether the insured amount can be revoked by Healthy Trip. Good one. Actually था ये कंज्यूमर का क्वेश्चन, बट ये रेस किया गया था इन कॉन्ट्रैक्ट के रिलेशन में, तो क्वाइट अ गुड वन. ओके. National Insurance versus Sima Malhotra case 2001. Supreme Court held that applying the principles envisaged in 51, 52 and 53 of Indian contract relating to the reciprocal promise, it simply says अगर आप अपने promises को honor करोगे then I will honor my promise. तो जिस person का insurance हुआ है उसे premium देना है to honor his or her promise, और सामने वाला अपने promises को honor करे. The insurer need not to perform his part of the promise when the other party fails to perform his part of the promise, thus not liable to pay the insured amount. तो यहाँ पे एक पार्टी अगर दूसरे पार्टी के सामने अपना पार्ट ऑफ परफॉर्मेंस नहीं करती, तो then it is not liable. So when the insured fails to pay the premium promised, or when the check issued by him towards the premium is returned dishonored by the bank concerned, the insurer not perform his part of it. Clear? अगर insured person ने अपना चेक दिया और वो dishonor हो गया, you cannot cast a responsibility on the insurer company to make the payment of this. Okay. This corollary is that the insured cannot claim the performance from the insurer in such a situation. As simple as this. You cannot ask a performance from a person to whom you have not performed your part of the contract. The contract of insurance therefore cannot be said to be performed. That's what the court is saying. So yeah, the claim of the insured amounts from the healthy trip cannot be recovered. So we have put down the answer. अगर आपको केस लॉ पता है, well and good. If you don't remember, वैसे कंज्यूमर में था, but if you don't remember, still you can write from the leading case law or you can discuss the contract act. But do discuss it well in the exams. Okay. Lastly, December 2020 का क्वेश्चन था, Amit's son absconded. He sends Suresh, his servant, in search of the boy. When Suresh has left, Amit by the handbills offers to pay 5,001 to anyone finding the son. Suresh finds the son after knowing about the offer. Can he claim the rewards? It is again Lal Manchukla versus God that he cannot claim the award. See, you can see this. Okay, so with this आपने देखा काफी सारे questions repeat होते हैं. So if you do at least these many questions, at least हमको एक idea मिल गया. Okay, this is the kind of question that could be coming for the examinations. Okay, so all the best for exams. See you next time.